No, no,
Okay.
it's a public meeting, so we live stream it and we record it for our YouTube channel for people to watch at a later date.
Thank you.
And we are live now, right? Okay, Madam Chair.
Hello, everyone who's going to watch this. We're having a special meeting to discuss equality of representation in districting in Mountain Parks Electric Service Territory. And we've asked Ty Thompson of the National Rural Electric Cooperative Association to kick this meeting off and give us an overview on districting and maybe how other co-ops have approached growth and proportionality of representation. So go ahead, Ty, if you would.
Want to introduce Ty's title?
Oh, he's the, yes, well, he's the chief attorney, is that it? I'm not sure his real title. What are you? For NRECA?
Well, I'm an attorney with NRECA. And I've been there since 1997, believe it or not. Before that, I was actually in private practice in Raleigh, North Carolina, and worked for the law firm founded by Bill Crisp, who was a longtime electric cooperative attorney. At NRECA, I focus on a lot of electric cooperative legal issues, tax issues, governance issues, operational issues, etc. And unless anybody has any questions, I can move into some of my comments on this topic.
I guess, do we want to introduce?
Yeah, we can introduce the board if we'd like. Justin, you want to start?
Hi, Ty. My name's Justin, and yep, been on the board for about 5 years now.
Super.
Hi, Ty. I'm Craig Healy. I'm a new board member since about May, and I'm up in the Fraser Winter Park area.
Morning, Ty. My name's Carl Trick. I'm from District 3, probably the largest district in the co-op, but with the least members. Basically, the whole county plus parts of 2 other counties. So.
Hi, I'm Jeff Hauck from Grand Lake area, which is up north of here. Been on the board about 12 years, I guess. Good having you.
Hi, Ty. I'm Liz McIntyre. I represent the South Granby area, but really also the co-op. And I've been on the board for, I don't know, 7 years maybe, something like that now. And I appreciate your willingness to help us out through this topic.
Hi, Ty. My name's Kristen Tedonio. I'm the representative from District 1.
And I'm Mark Johnston. I'm the general manager. And then the other screen that we have is Levi Williamson. He is our the board's, well, not the board's, sorry, Mountain Parks attorney. And sitting behind me is Joe Palmer. He's the head of our IT group. He makes the pictures work. And the other individual, Scott Simmons, is the head of our engineering group.
Well, thank you. And I'll move ahead unless there's anything else.
Go ahead.
Levi, it's good to see you. We spent an extended period of time in the Monterey airport a few days ago waiting on a delayed plane. So
luckily I had a direct flight. I didn't have to get delayed even more in Denver.
I missed my connection in Denver, and the day just went downhill from there. But I did make it home. So good to see you again, and
good to see you.
Thank y'all for inviting me to address this topic. And I'll just be honest. This is one of the more difficult topics that I'm asked about. And I'm asked about it frequently. One of the reasons that it's difficult for me is that because it's a difficult issue to address or to answer questions about, because from a legal perspective, there's not a lot of true legal guidance out there. But I will tell you that a lot of electric cooperatives across the country struggle with the issue of director districts, what the boundaries should look like, how often they should be reviewed, and things like that. And I'm often asked, what are the legal parameters around director districts? And I'll first note that certainly the legal considerations are an important consideration, as they are in any business decision. But there are other considerations, whether that's member relations, public relations, et cetera, operational, logistical considerations, et cetera. So I freely acknowledge that, but certainly my focus, my expertise is more on the legal parameters and in the legal realm. And outside of state law, which Levi, correct me if I'm mistaken, but I don't think there's any specific guidance in the Colorado statutes. At least I didn't see anything after a quick look, as far as the parameters or boundaries of director districts.
No, it's allowed to have districts and to vote by districts, but I'm not aware of any law specific to how to district.
And that's very common around the country. Most electric cooperative acts permit or authorize director districts, and that's about all they say. So there's not a whole lot of state law guidance really in any state that I'm aware of. What little legal guidance is out there, I think probably falls under federal cooperative tax law. And I'm sure y'all know this, but one of the three cooperative principles, that is one of the three requirements for operating on a cooperative basis under the federal tax law, is that you operate under democratic member control. That's not a new topic. It's certainly an important topic for electric cooperatives and any cooperative. And when you dive down into what that really means, that there's not a whole lot of bright line guidance. But generally speaking, at least one notable court of appeals has indicated that, okay, democratic member control, we're really talking about members, exercising some type of franchise of roughly equal strength. Now, what that means is subject to debate. One thing it certainly means, and the IRS has followed this, particularly for electric cooperatives, is one member, one vote. Doesn't matter how much business you do with the cooperative, you get one vote. So again, one member, one vote, and that's not a new concept for electric cooperatives. And I would also like to pause and emphasize something. When we're discussing director districts, it's an important issue when it comes to director nominations and elections. But in my experience, it's irrelevant for any other member vote, whether that's votes to amend bylaws, votes to dissolve, votes to merge. So director districts, again, are important when it comes to nominating and electing directors, but they're irrelevant for any other member vote. And I'm assuming that's the case at Mountain Parks as well. So again, they are important, but only for one aspect of democratic member control. Admittedly, an important aspect of democratic member control, but still it's board focused. And the courts have also said that the cooperative principles, including democratic member control, are important. And if you have a substantial departure from them, then that could jeopardize your cooperative status under federal tax law. And of course, that would impact both your tax exemption and even your treatment as a taxable rural electric cooperative. So losing your cooperative status under federal tax law it's a big deal. And the courts have said substantial departure from those principles, that could be a problem. Now, substantial departure, what does that mean? It's a subjective term. People can disagree regarding what that means. Ultimately, it would be the IRS and the courts that decide whether there was a substantial departure. When I look at the cases, and there's been 2 or 3 private letter rulings addressing this concept of director districts. Notably, the IRS private letter rulings, and honestly, most of them are a couple of decades old, but they've clearly permitted, director districts of unequal size, both in geography and in the number of members. So you do have some latitude, at least from the IRS's perspective. But when I address this topic, I usually try to pull everything together. That is, pulling together the private letter rulings, the tax guidance, the case law, and come down to, as long as your director districts are not grossly disproportionate, or as long as your director districts are not substantially unequal, you're probably not going to have a problem under federal tax law. Now, I'm the first to admit that the terms that I just used themselves are subjective and don't provide a lot of guidance, and people can disagree about what they mean. But if you're looking for some general, I guess, guidelines, that's what I've fallen back on over the years. You want to avoid districts that are grossly disproportionate or that are substantially unequal or inequitable. Again, people can debate what that means. And in analyzing director districts, again, I think it's fine to include items like the number of members in a district, the geography of the cooperative service territory, perhaps the type of load in the district. So again, I think all of those are legitimate considerations. And I'm unaware of any bright line rule for any of those. So again, you've got some flexibility. That's both good news and bad news. The good news is you've got flexibility. The bad news is that there's not that much bright line guidance. And that's often, in my experience, what cooperatives are seeking, some more bright line guidance, and it's just not out there. Now, having said all that, I will also note this. I am unaware of the Internal Revenue Service ever raising the issue of director districts in an audit of an electric cooperative. I don't think it's on their radar screen. I don't think it's something they focus on. So again, in my experience, I'm unaware of the IRS ever questioning or challenging a cooperative director districts. Now, and I will also note, when it comes to tax law, it's up to the IRS to enforce tax law. That's not something that in general that a private citizen could pursue legal action on. So it's up to the IRS typically when it comes to federal tax law, including director districts. Now, having said that, if you have a member or a private individual who is concerned about a cooperative's director districts, that they do have the ability to notify the IRS or to point it out to the IRS. But ultimately, it's the IRS that decides whether to do something or not. And again, in my experience, it has never been raised during an audit. And going back 15 years or so ago, when we had some conversations with the individual who at that time was heading up the electric cooperative group within tax exempt organizations at the IRS, and we asked him about director districts. His response, and this was not an official response, but his general informal response is, we're not really that concerned about it. They're focused on other issues. Now, again, that was one individual that was over 15 years ago, but that I kind of guess gives you a sense, perhaps, at least informally, of where the IRS is on this issue. And again, what little legal guidance out there, it probably flows from federal cooperative tax law. Now shifting to your situation, I noticed that your director district boundaries are specified in your bylaws. I will tell you that in my experience, that's unusual. it may be common in Colorado, I don't know, but in my experience, it's unusual to have the precise boundaries in the bylaws. Most bylaws that I've worked with address director districts, but defer or delegate to the board that the practice of actually drawing the boundaries. And there might be some general guidelines in the bylaws, but bylaws defer to the board to actually draw the boundaries. So and I'm not suggesting it's either good or bad that your bylaws are that specific. I'm just noting that struck me as I was just glancing through the bylaws. And I guess, putting on my attorney hat, and if I understand your bylaws correctly, and Levi, please correct me if I don't, but it appears that if the members are unhappy with the way that the director districts are drawn, there is a mechanism through a type of member petition for them to propose a bylaw amendment, I think, redrawing those boundaries. So there is, some clearly specified member legal recourse if there's discontent or displeasure with the current boundaries. I will tell you, most cooperatives don't have that direct of an access or a recourse available to members. So I think, again, putting on my legal hat, that's a factor that weighs in your favor. Whatever you do or don't do, that is, if the members are unhappy, that they have some recourse to change things. I will also note when I'm discussing this issue with cooperatives, again, with my legal hat on, to the extent there is any, the legal concern is mitigated when you have, I'll just call it nominations by director district, but election at large. That is, everybody votes regardless of the director district. But I understand that that's not your situation. Again, Levi or others correct me if I'm mistaken, but I understand that you both nominate and elect by director districts, and there's certainly, that's a minority among electric cooperatives, but it's a significant minority. I mean, so there's a lot of cooperatives that do nominate and elect at the district level. Again, to the extent there is any legal scrutiny, it's enhanced a little bit if you do both nominate and elect at the district level. Now stepping back from that, I'll also point out, and this is not news, but regardless of how you're elected, at least in most states, once you're on the board, your fiduciary duty is owed to the electric cooperative, regardless of the director district from which you were nominated and elected. And again, just giving you a little bit of comments from my perspective. Again, this is a tough issue for a lot of cooperatives. I'm unaware, outside of the tax context, unaware of any legal challenges to an electric cooperative's methodology of how it draws its director boundaries. I will say it did come up in an allegation in a New Mexico lawsuit years ago. That lawsuit really focused on some other capital credits and governance issues, but there was some allegations or questioning about the drawing of director district boundaries. That lawsuit ultimately went away for various reasons. But I've never seen any challenge in any litigation against electric cooperatives. And you may be aware, that there's been some questions, or at least increased attention focused on governance at electric cooperatives in certain years. I'm unaware of any of that attention being focused on director districts. So I don't say any of that to mitigate the importance of director districts, but just to point out from a legal perspective, the true legal risk tends to be fairly low. But again, that does not minimize the importance of the issue. Also, most cooperative director districts are often tied back to geographical references that have been around for decades. And sometimes that's townships, county boundaries, again, geographic boundaries, landmarks, and that has tended to work well over the years. and to the extent cooperatives have adjusted their boundaries, in my experience, it's been minor tinkering. And unless the board is really doing an overall revamp of its board, or unless it's merging or consolidating, at least in my experience, there's been little wholesale revision of the director districts. Again, that they've been modified, tinkered, and adjusted as appropriate, but not wholesale, I guess, throwing out the old and bringing in the new. And I don't say that to say that it's a good thing or a bad thing. That's just been my experience. And looking at your bylaws, I guess that the underlying the question is that the obligation to review them and ensure that the director districts ensure equality of representation to the extent practical. And then they list some other considerations. And again, those terms are subjective, and people can agree or disagree regarding what they mean. I will say in general, and I don't think there's anything unique in Colorado, but in general, an electric cooperative bylaws are enforceable as long as the bylaw itself is reasonable and it's applied in a reasonable manner. So I guess from a legal perspective, that there is, an anticipation that bylaw would be applied reasonably. But again, that's subjective and subject to dispute. But nonetheless, it does provide, some considerations, and I think that's helpful. So that's a lot of comments by me. I don't know if it's helpful or not, but again, this is one of the more difficult questions I'm asked about, just because I typically don't have a very concrete or readily helpful answer. So I'm happy to answer any questions or give you any other thoughts that you would like.
Kristen has a question.
I have 3 questions. I'll start with perhaps the most straightforward one. Ty, in the NRECA documents that we study for our credentialed cooperative director certificates that we're required to get here at Mountain Parks, there's a provision that discusses member districts, and it states that if a co-op does decide to elect directors by districts, those districts should not be substantially unequal. Can you just tell us a little bit about why NRECA put that in the CCD textbook? Why did NRECA feel that was important? And you talked a little bit about a follow-up to that. So there's some subjectivity around what is substantially unequal. And you would probably have to go to the reasonable person test. Can you talk a little bit about that and how a subjective question might be resolved, or how you want to think about that from a lawyer's perspective?
Well, thank you. In answer to your first question, I think that language is in the training course because of me. But I think they misconstrued or miscommunicated my comments, and I followed up with Pat Mangan on that, because what I've told y'all, I think is the message they were trying to convey. But again, I think that their terminology and perhaps the words they used was a little bit different. So I apologize for that. But I think the reason they were addressing it is the reason that I noted earlier. There needs to be some awareness that at some point, your districts could become so disproportionate, inequitable, et cetera, that it's conceivable that the IRS could raise an issue. So again, my guess is that's why that's in there, is because of me. But again, I think something was lost along the way, because I don't recall reviewing that particular language. Considerations of reasonableness. I mean, that's the heart of the issue. I will say in at least one IRS, private letter ruling, and Levi, if you're interested, I'm happy to send you those sites. But the IRS acknowledged that you're having different numbers of members, and these were not electric cooperative rulings, but they were cooperative rulings. Having different numbers of members in different districts to allow you to facilitate more geographic dispersion was fine. I think in that case, Most of the cooperative members were allowed around one geographic center, but the cooperative had some other director districts that had less members, but the IRS kind of acknowledged, you know, geographic diversity, that is a legitimate consideration when you're drawing these lines. Certainly the number of members is a consideration. The type of load can be a consideration. Is it commercial, industrial, residential, et cetera? So
How does that intertie with one member, one vote though? And that, you know, explicit IRS requirement? You know, if we're just like, oh, the load is bigger here, there's 2 members, can we draw a district around it?
Well, good question. Now, bear in mind, there's often confusion because in all of these, each member still gets 1 vote, period, regardless of their director district. So it's that topic is often brought up in this discussion, but it really is a different topic because everybody still gets 1 vote, period. The issue really is board representation or the perception of board representation. And that's where the issue arises. Now, I'm not suggesting that you should draw a line around 2 large industrial members and give them a seat themselves, but I am suggesting that from an equitable representation on the board perspective, large loads have some unique considerations. The residential loads don't. And I could see that factoring into, hey, if we need to represent our membership equitably, you know, maybe we need some a district that is heavily C&I. I will tell you, there are some cooperatives where 70, 80, 90% of their load is commercial or industrial, and they're very much want some of that input on the board. So in answer to your question, I don't see a direct conflict with 1 member, 1 vote. It's more a matter of board representation. And would the board benefit from that perspective?
And then the second question that I had was on the reasonableness standard when it comes to judging whether or not there is equitable representation for members and we're meeting that democratic control standard.
Yeah, and that's a tough one because again, you could get a room full of people and they might all have different perceptions. I will tell people when I'm discussing this topic that at the end of the day, my sense is most directors, most individuals know in their gut whether there's a problem or not. And if they're honest with themselves, they know whether there's a problem or not. So I often encourage people, what does your gut say? Because intuitively, there's generally a sense of whether we have a problem or not. But going back to your question of reasonableness, I don't know what guidance I can provide because again, I think some of the issues, considerations would be number of members, type of load, geographic dispersity, and diversity.
I'm talking about the reasonableness standard, not about this one particular issue. Like in fiduciary duty, for example, when our attorney talks about how if there's, you know, a lack of clarity, what would a reasonable person consider? Like, for example, if we're confronted with issues, we may not be experts as directors about any particular issue, but, you know, you have to act as a reasonably positioned person would be expected to.
Yeah, and I guess it sounds like there's kind of 2 aspects to the reasonableness in this discussion. One is that the reasonableness of the districts themselves, however they're created, by bylaw, by members, et cetera. So that's kind of one consideration. Then the other, it sounds like you may be more focused on is a reasonableness as far as the board's activity on this issue and board's discussion, and what the board might propose. And I mean, you hit the highlights of the reasonableness standard. Yeah, what will an ordinary person in a like position under similar circumstances do in this situation? I will tell you from a fiduciary duty perspective, directors are obligated in most states, and I'm assuming this is similar in Colorado, to act in a manner that they reasonably believe to be in the best interest of the entity. Now, typically there's 2 aspects to that. That they generally themselves have to subjectively believe that their vote, their caption is really in the best interest in the cooperative. So there's that subjective element. They actually have to actually believe it. And there's also an objective aspect to it. It's got to be, believable by the reasonable person. So those are kind of the two prongs, but ultimately, yeah, the directors are obligated to act in a manner that they believe to be in the best interest of the cooperative from a fiduciary duty perspective. And I guess when it comes to this issue, there's kind of two legal routes. One would be, hey, these director districts are unlawful. They violate the bylaw. They need to be redone. However you get there. And the other aspect would be board of directors, you're violating your fiduciary duty. My sense is, based upon my general knowledge of corporate law and things like the business judgment rule and things like that, I think a lawsuit for breach of fiduciary duty would be difficult, unless it's just demonstrably horrific. I think any legal action related to breach of fiduciary duty would be tough, unless you can point to bad faith, self-interest, very specific self-interest. I think that would be a difficult legal proceeding for somebody to have success on. Now, if you're looking at a lawsuit focused just on the director district, saying, hey, they don't meet the bylaws, that's more, I guess, winnable per se. But again, there's a lot of subjectivity in that type of pursuit. So I don't know if that answered your question or not.
What's a private letter ruling? You mentioned a couple of those. It's not a lawsuit, it's a...
No, a private letter ruling is basically where an individual taxpayer goes to the IRS and says, here's what we're planning to do. Will this cause us any problems regarding our particular tax position? They're not cheap. I think the filing fee is like $30,000 or $40,000 with the IRS, but the taxpayer is basically going to the IRS and asking, if we do this, is it okay? And the IRS will reply. Now, the good news about a private letter ruling is it's binding precedent for that particular taxpayer. The bad news is it's not binding precedent for anybody else. But it is evidence of how the IRS would treat a similar scenario. They tend to be very fact specific. And in the electric cooperative tax world, we tend to rely on private letter rulings a lot because there's not a whole lot else out there. So when it comes to private letter rulings, I generally say they're not precedent setting, but they are evidentiary. They are a piece of evidence of how the IRS interprets tax law under certain facts. So they're helpful, but they're not binding precedent. But again, we tend to rely upon them in the electric cooperative tax world just because there's not a whole lot out there to rely on.
Who can ask for a private letter ruling?
Any taxpayer.
So could a member of ours ask for a private letter ruling regarding Mountain Parks Electric, or does Mountain Parks Electric have to ask for it?
It would need to be the taxpayer. In your situation, Mountain Parks Electric.
Okay, thank you.
And the reality is, when these are requested, there's often some give and take between the taxpayer and the IRS. And if it looks like you're going to get a ruling that you don't want, often the taxpayer revokes the request. But it would be the taxpayer. And again, there's a big filing fee with the IRS. I think it's $30,000 or $40,000, and then you would need to retain a tax consultant to help you through the process. I don't know if Levi does that type of work or not, but it's a very niche industry.
I do not.
Okay.
Does anyone else have questions for Ty? Ty, as you have dealt with co-ops around the country, if co-ops are rapidly growing in sort of uneven growth patterns, what sort of approaches have you seen them take to try to adjust so that they don't have any issues with equality of representation?
As I noted earlier, tinkering with the boundaries. Again, seldom do we see wholesale changes, but adjusting the boundaries to the extent feasible to address that. And some cooperatives will split a district if they have one that's just growing demonstrably. Instead of tinkering with the others, they'll simply cut that one in half. Now I realize that's a drastic change for that district, but either tinkering, I'll call it, overall, or splitting the district in half. I can tell you most of the wholesale changes arise when a co-op is merging or consolidating or otherwise doing something significant.
Okay, and you also mentioned voting at large would be another way.
Yeah, and that's,
do you see much of that?
the majority of cooperatives today will nominate by district, but elect at large. Again, there's a significant minority that do what y'all do. So already the majority nominate by district and elect at large. Now, when we say at large, that also could have another meaning, that is a specific director seat that's not tied to any particular director district. And yeah, some cooperatives that have gone that route and just say, well, we're going to add another the director position or two or whatever. And this director position is not going to be tied to any particular director district. And the individual could be nominated from the service territory and elected from the service territory. So that is an approach. I haven't seen that being that widespread, so to speak, but I have seen more of that, where we just create a new position and everybody nominates and elects for that position.
And have you seen, do they sometimes, rather than splitting a district, just add another representative to that district?
Yeah, and that's the other approach. And that most cooperatives prefer to have the same number of directors elected from each district. And so when you add one to one district but not the others, that could complicate things. But in answer to your question, yes. But again, I think most cooperatives, rightly or wrongly, like to keep the same number from each district. But yes, that would, I guess, achieve a comparable result.
When you think of these approaches, do you think of pros and cons to the various approaches?
It's tough. I mean, like with anything, there's advantages and disadvantages to each. And part of this is administrative, logistical, et cetera. You know, tinkering around the edges of boundaries, that creates, I guess, the least amount of turmoil. Dividing a district is fairly straightforward and easy to get there, but it's a fairly drastic change. A lot, and I don't recall your election cycle now, but a lot of this is influenced by just the director terms, how long they are, and your cycle of staggered director elections and who's doing what. So again, it's hard to really identify specific advantages and disadvantages because in my experience, certain cooperatives are more interested in certain items than others may be. I do think it's important, and I'm glad you're having this meeting to focus on these issues, to document that you're having this meeting and that you're having this discussion. Because I will tell you, from a fiduciary duty perspective, I think it's what's more important is the fact that you're paying attention to this and having this discussion, as opposed to any action you may ultimately take or not take. You know, documenting the fact that you're having the discussion, considering all these issues is critical from a fiduciary duty perspective. But and again, I'll tell you, you're not alone in wrestling with these issues. A lot of boards struggle with this.
Carl?
Is there any cases where a district is not connected? In other words, part of a district can be located here, but not connected to another spot that is that same district, but not interconnected? You understand what I'm asking or not?
I do. I haven't seen much of that. The one or two times where I may have seen it is where a cooperative acquired a new territory from an IOU or somebody. And to make things work out right, they combined that new territory into an existing district that may not be adjacent. But in my experience, yeah, most districts are contingent within the district. That there's not a gap between parts of the same district.
But there's no rule or regulation or anything else that they have to be, is that correct?
Yeah, I'm unaware of any.
Okay.
Yeah, I'm unaware of any.
Okay, one other question. Does seasonal membership play any role in districts and district boundaries and voice of the co-op?
So can I just give a little information to Ty, just so he knows, so he can work that into his comments? So Mountain Parks is, I forget what the percentage is of seasonal homeowners, but
We have about 60% of our members that are second homeowners. I don't necessarily know that they would qualify as seasonal, but
sure.
they own the residence. It's just it's not their primary residence.
And is that what you meant, Carl?
Yes, they're
Second
members
homeowners.
they're legitimate members of the co-op, but they are
Mountain Parks, they do not
discriminated
need
against.
directors. Ty.
They are discriminated against in certain aspects of co-op, activities. And so I just was curious if that issue is.
To the extent the word discriminate means treated differently, yes. Second homeowners are.
They can't be on the board,
not
for instance.
eligible for a seat on the board.
And that's where when you talk about seasonal members, that's usually where the issue arises, is their eligibility to run for the board of directors. And having discussed that issue, we've got co-ops that disagree on that precise issue. But yeah, that issue usually arises when it comes to director qualifications. But so I haven't seen it discussed or addressed as much in the context of director districts, but yeah, I can see where that would be a consideration. Again, most cooperatives don't have that high a number of seasonal members, but certainly if you do, I can see that impacting. At least I could certainly see that as being important to somebody, or an important consideration among other considerations.
I'm not sure I'd necessarily term them as seasonal members. Maybe members who don't have their primary residence here, because they come at all times, and they're members. Seasonal membership to me would be more like the folks who come and get a job, move into an apartment over the winter to service the ski area. And then, so when they move in, that service is changed into their name, and they're a member just for 6 months or whatever, and then they leave in April, and the meter goes back to the landlord's name. And so that we have some flux of membership there, and those truly are members who are only here for a very short time during the season. But they're still members. You don't really know that they're going to leave in April. So they're members when they're members.
And I will tell you more generally, I think when co-ops discuss quote unquote seasonal members, and I don't disagree with you, but I think they're referring to non-permanent residents, whether that's second homeowners, vacation, people that are there for, during the summer or scattered throughout the year, but non-permanent ownership. At least that's how the term is often used. But I hear what you're saying. You could define it differently. But I guess what's important is the concept that you're referring to. So I certainly hear how you're describing that term.
Any other questions for Ty? Jeff, there's nothing burning inside you
No.
to ask?
I think in our bylaws, we have something that a member has to live within their district for a certain amount of time, so to be a board member. So I guess that would be, I mean, if somebody owns a meter here but doesn't live here, they still, that's something we should look at.
Hi, are you familiar with other co-ops that allow any member that can, meet the requirements for being a director to run for the board, regardless of whether or not they are a full-time resident?
And I call part of that, that is an issue that co-ops debate about whether you would only allow full-time residents to be eligible to run for the board. Most cooperatives, in my experience, their bylaws do provide that, yes, you've got to be a full-time, I'll call it a permanent resident in order to run for the board. But that's not true for all cooperatives, but in my experience, most cooperatives do have that. And increasingly cooperatives are saying not only are you a permanent resident, but you've been there for a certain length of time, whatever that length of time is.
Any other questions? Craig, do you have any questions?
I'm making notes in my head for later. Thanks, Ty.
Yes, thank you, Ty. This is our last chance for any other thoughts. I think I got mine.
Ty, if you can either provide the site for the private letter ruling to Levi or myself, we'll make sure that we get copies to the board.
Okay, yeah, I'll send you that stuff.
Ty, I had one more thing that I noted, which is, and you touched on it a little bit, which was sort of the disruption if you do big changes, the disruption to the election cycle, and from a governance perspective, it seems like if you're really rapidly growing that you might, and you change these things often, you could have more disruption to your election cycles and just your overall board and governance. Do you feel like there's an approach that minimizes that disruption?
I can tell you practically, most cooperatives or a lot of cooperatives are addressing these types of issues. They usually time it so that it coincides with the director's retirement or some other shift in the board composition to hopefully minimize the disruption. So that is often a catalyst, whether it's resignation or unexpected death or unexpected disability. Something else that's already disruptive is occurring, and that usually facilitates some of these discussions at that time, so that you're kind of minimizing the overall disruption from a governance perspective. I mean, rightly or wrongly, I think practically that's often what happens.
Great, thank you. Carl.
Ty, a little different question, kind of off the topic a little bit, but are there many co-ops that have term limits for directors?
Another hot button topic. In my experience, no. In my experience, the majority of electric cooperatives do not have term limits. Some do, but in my experience, it's a minority that have term limits. Now, when I say that, I'm not speaking for or against term limits, but just practically in my experience, most electric cooperatives do not have director term limits.
Thank you.
Anything else since we're branching out? We want to know. I think it's great. I think having Ty here and being able to ask these types of questions, not just on the districting, but on who can run for the board and term limits. And is there anything else we can think of that we want to ask about what other co-ops are doing out there? Hey.
Hey, tell us a little bit more about the at-large election? Does this typically happen when people are doing an election for several board members at a time, and then there's an at-large member as well as member nominated from a district?
Yeah, it sounds like you're talking about just a specifically designated at-large director. Yeah, and usually that would happen at the annual meeting, because again, the majority of cooperatives have the election at the annual meeting, and just like they're all voting on the directors that are coming out of the director districts, they'd all be voting on the at-large director at that time. And he or she would have a term of 3 years, and 3 years later, you would do the same thing. But it's typically at the annual meeting.
And is the nomination process, have you seen for the at-large member, is it similar to the districts, or are they required generally to have, greater, well, we do ours by signatures from the members within the district. Would the burden for an at-large candidate be larger or sort of the same, do you think? Or what do you?
In my experience, it's the same. It's either, perhaps nominated by a nominating committee and or member petition. The same number of signatures would be required. That the only thing is that they could come from throughout the service territory. They would not be restricted to coming from one particular director district.
And can you contrast an at-large director to at-large voting for all the district directors?
Yeah, at-large voting is a scenario where each individual, a candidate would have to be residing in a director district to be nominated from that director district. And it could be 1, 2, 3, however many nominees you had. And then when you go to the annual meeting, the entire membership would elect directors. The entire membership would vote on who would be elected from District 1, for example. So that members and districts outside of District 1 could actually vote on who was being elected from District 1. So it's everybody's voting at that point. And that's why you would come to the annual meeting and you just have a membership-wide vote on the positions that are open for re-election that year.
You've made a couple of times a distinction between, voting and voting at the annual meeting. The way that we do the voting is ballots are sent out and members can vote either by dropping off their ballots. We have drop boxes. They can mail them back, or they can actually vote at the annual meeting. When you say vote at the annual meeting, are you encompassing all of those things that the voters have the option to vote?
I am, and I guess I'm trying to contrast that with some cooperatives. If they elect a district, they actually have district meetings, or just do things on a district basis, including the election. So, in answer to your question, yeah, when I say annual meeting, I'm encompassing voting at the annual meeting as well as mail voting, electronic voting, whatever you might have.
Right. Anything else? Thank you, Ty.
Okay, thank you, and good luck with everything.
You bet.
All right.
Thanks, Ty.
Thank you.
Let's take 5 minutes, digest what he said, and when we come back, I think we should talk about the various approaches, the pros and cons, and just have a discussion about what people think about the various approaches, and then we'll try to narrow them down. Okay. So
Since he's.
Oh,
I've seen it.
That's probably a better map.
It'd be useful
For purposes of the Zoom, because I don't think anybody can see.
okay, so while Jill's working on putting the map up, I just want to go over the approaches I heard, add one, and then make sure that I miss any that you guys might have heard. So there was tinkering with boundaries, adding a district or multiple districts, voting at large, but nominating by district, adding a director at large, adding another director for a large district, so you get two for one. And then the last one, I would add that the approach would be that we do nothing. I think that's something we have to, the board, that should be an option that the board discusses. So that would be the last thing we put on the board. And then we can go through, discuss pros and cons of each of the approaches, is what I was thinking. I'd like to hear what your thoughts are on each approach. Yeah.
Before we get into the approaches, for those of us who are newer members, could we ask just a couple of history questions to understand where you all have been on this before and kind of how we got to the current?
Just for reference for anybody who might be watching, the map that is on the screen currently is also available in the 2021 annual report, which is available on our website.
And on that vein, little historical footnote, this meeting had been requested by 4 of the district members to discuss whether or not Mountain Park should consider redistricting. In our bylaws, it says that we have to meet as a board to consider redistricting in order to assure that we are a democratically member-controlled cooperative, and that generally translates to assuring quality to the maximum extent practical for members. Right now, we do have a situation where next year, District 1 and District 3 are both electing a new director. I had brought this up just because I, as a director, was unaware of the number of members voting per district and, advertising the fact that my seat's going to be open, that's District 1 next year, and asked for a list of the number of members per district, where it became evident that right now we are in a situation where the majority of members do not necessarily have a majority of the board seats. And so I had said, well, don't we want to be in a situation as a co-op where the majority of members have a majority of the board seats? And this is in part because some of our districts, particularly the ones that are concentrated in the south and east, 1, 2, and 7 all have 3,000 plus members, while some of the more rural districts like District 3 have less than 1,000 members. District 4 has 2,000. You add those together, that's still fewer members technically than just one of those districts in the southeast. And so that kind of created a lively discussion about why things came to be that way and whether they were discriminatory or not. And here we are today. And I believe that was 6 years ago, was it? So we are.
So
that we last redistricted.
We looked at this, I believe, starting in 2015. In 2016, the bylaw amendment passed, and in 2017, I believe, that was the first election for the new districts. And I believe that was you and I, Justin. The board went.
Peggy was the first.
The board went both, yeah. Peggy might have been the first. I know that I was appointed to my seat, but then had to run for it again within a year, less than a year. And that was part of the when we talk about redistricting and adding districts, that's part of the complication. We are on 4-year terms. And District 1 and District 3 are up in 2023. District 4 and District 6, which is Kremling, it's the Kremling, Summit County, Willow Creek, Ute Pass, and the Hot Sulphur North Granby District is District 6. Those are up in 2025. District 2, I misspoke. District 7 is also up in 2025. And then the Grand Lake District and the District 2, which is the west side of US 40, is up in 2026. So we do have 2024 as a year where there is no election because we're on a 3-year, we elect 3 years, and then there's a year where we skip because we have 4-year terms. So as we think about changes, that schedule could have to change. If you add another district in or whatnot, you have to think about how that schedule runs. I know that I spent a lot of time thinking about that. We changed at the same time from going from a 3-year term to a 4-year term. Part of that was just as a way to give people longer time to get their feet under them, but also a way to reduce the costs to the membership of adding another district.
And if you add or subtract
Right.
a seat, then you have a potential for a tie in the votes. Now it's 7, so
Right.
you take one away or you add one, you're in that situation.
And that was one of the reasons we added.
And it cut up. Yeah, I mean, the ones that got the majority split up were 6, 7, 1, 2. I mean, all of those went into making that.
Yeah. Yeah, we sort of shrunk those.
I think it's
expanded others.
It was the first year that AU is.
Right.
And then just because I've been through the process now of trying to run in District 1, which we as shorthand call Fraser, but it's actually hard because it's not Fraser. If, people down there that were running for the board could just say, if you're in the town boundaries of Fraser, that's District 1, that would be really easy. But instead, it kind of follows these parcel lines that you have to be a surveyor to really understand if you read the bylaws. So could you walk me through why the districts look like that and not aligned to the zip code?
I would say then if we said to you, if we made a district out of Fraser, then there'd be a donut district around Fraser. It's the unincorporated area. Mm-hmm. So you'd have what Carl was talking about, which is, little spots. I don't know what the actual meters in the town of Fraser incorporated would be versus then going out and looking in the county areas and trying to balance that all out. Or Winter Park. I mean, I think that the idea was to just take, I don't know, I wasn't here when the co-op was formed, but I think the idea was to just take broad geographic areas and say, this is where we serve, and so we should have a district here. I mean, you're right, it makes, in some ways, Carl's district is pretty discrete, although he has part of Larimer County and has a little bit of Routt County. Oh, I guess Mark has Routt County.
I remember whoever did it on the GIS and everything, it took forever, tons of time. Because they kept coming back. So they tried to get it as equal a split between 1, 2, and 7 as possible with keeping straight lines. And
how come we were just looking at our numbers right now, we have over 17,000 members. If the number of members per district was equal, it would be roughly 2,500 or 2,526 members per district. But during the last redistricting, we decided we were only going to look at keeping the numbers even for the southeast corner.
Oh, well, I'm going to let Cray speak, and then I can try to answer that a little bit.
Well, while I was thinking just now, Justin touched on it. So Joe, this is a question for you or someone on staff. You alluded to the GIS difficulties a few years ago on massaging and investigating district shapes. Does the GIS system now, can we click it, as we get further into this, can we click and drag and do different things? And then the numbers of meters in districts would change, kind of like a map quest where you change your route and then all of a sudden it.
And the answer is no. Yeah. With the GIS system has that capability. We don't have on staff that expertise to do that. And you weren't here for the original discussion that Kristen referenced. I talked about the possibility of hiring someone with that expertise to create a model of our system with the meters that you could then adjust the lines and then it would adjust the number of meters.
Okay. Because I'm GIS qualified, but enough to be dangerous. But I know that that's a tool out there that you can use, and it's pretty straightforward, whatever the data set is, whether it's number of manholes or number of transformers that you can, drag stuff around. That might be a good tool if there's something, if this is kind of a longer term project that we're not going to solve today, it might be worth investigating. Is that a $3,000 GIS item or $30,000?
I would say it's closer to the second than the first.
But you don't know, for sure.
But that might be a tool for us to have.
So one clarification I can give is we have, since the time this was done, we have a new enterprise platform that we use, which is NISC. And so how it was done last time will be I'm just saying, will not be exactly how it's done this time. And so thinking about long-term and adjusting boundaries, having that expertise would be nice. How much do we want to pay for it? That's a question, if it shows up in the budget for 2023. As a board, we can decide, yeah, that's a reasonable expense or not. I mean, but right now, from what I understand, we don't have the ability to just go in bingo bango and do this. But it's out there.
Yeah.
And to Kristen's point as to why the last time we looked at this, the discrepancy, my hunch is the discrepancy between the districts was not as large. But also, I think that the board felt it was important to hear from the voices of Jackson County residents, Kremling residents, or members, I should say, folks in those areas. And it would be difficult to have them represent it would be difficult to put Grand Lake with Cowdrey. It's a long ways away, and the geography is different. The people are different. Well, they're still people and all, but we do different things. Yep. And it would have been hard for someone who's in Cowdrey to come down and listen to someone in Grand Lake, or the same for maybe you'd have more meters in Grand Lake and they would have to travel up and represent that person. Go ahead, Craig.
Well, in my thinking as this process evolves, I put great weight in Ty's comment on geographic diversity rather than just numbers. And so to me, that's kind of the flavor of Grand and Jackson counties is our rural nature. And that's part of who we are. Also, Fraser and Winter Park are part of who we are. Mm-hmm. And that's something I really keyed in on his comments, Ty's comments, is geographic diversity.
So do you think that in what IRS views as fair aside, and perhaps what the members in Fraser view aside, do you think that we should discriminate by giving more representation to people that happen to live in Jackson County or Kremling, or to the extent that they do have overrepresentation on the board from an electoral standpoint?
Well, we're never going to have a perfect world, but that terminology, geographic diversity, allows us some flexibility.
Does it allow us to give 3 times more voting power to people because they happen to live in a different part of our territory?
But
It could. That's to be determined by the end of our discussions. But I
didn't hear that from the attorney.
Go
That's an
ahead.
issue.
Yeah,
Go ahead.
But you're also segregating out Fraser Winter Park Valley, but I mean, why do you not throw my Granby district into your group?
Absolutely.
So
I
then you'd
mean,
have a majority as a.
so wait, are you saying if we add more members?
No,
to
I'm
this,
just saying
delete-
you're kind of separating out Carl, Mark, and Jeff or my district separately, right? You're saying that there's 4 districts that are representing the minority.
I'm saying that if you add up districts 5, 6, 3, and 4, that brings you to 8,518 members versus 9,167 in this little corner. Now you could add, actually, I'm not sure, you do get to a majority if you add one of the other districts. But that being said, like, we have a situation where some of our districts have 940 members, they get a seat. And we have a situation where some districts have 2,800 or over 3,000 members and they get 1 seat.
Jeff.
And I guess my comment to that is, that's what I want to see, because I want to have somebody like Carl up in Jackson County, because our fiduciary duty is to vote for the whole membership. So I want to know what's going on up there, and I wouldn't, I don't go up there very much. I don't know what's going on in Kremlin very
Just
much.
establishing for the record, you guys want to see discrimination so that we are overrepresented.
It's not discrimination.
I think that's a mischaracterization.
It sure is.
My point was that I'm flexible and I'm not keyed in and decided 100% on geographic diversity. But I like that terminology that allows
It
us in
sure
the
sounds better
discussion
than discrimination.
to
I
have,
agree.
to have that. But one, this is a little separate, but it is interesting that districts 1 and 2 are, it's an easy geographic boundary is Highway 40.
Right.
So districts 1 and 2 have parts of Fraser, parts of Winter Park.
Right.
And it's easy to just run down the highway, and that might be food for thought. But Kristen, no, I want to be very clear that geographic diversity is not my soapbox, but it's going to be a little part of the toolbox in the discussion.
So why shouldn't, if we do represent everyone, why shouldn't everyone be able to vote on all of the nominees in the districts? Because then you still get that geographic diversity. Why?
You also, I think that geographic diversity also plays into that a little bit. Carl represents, I think, what is our largest load also, which probably drastically conflicts somewhat with people that live in Winter Park, Fraser, Graham. There's different, the oil and gas field up there, I think at one time was our largest load and is the main, is one of the main employers of the folks that are left living in Jackson County.
And we have big loads in, District 7, 1 and 2 as well.
A couple.
Yeah.
Ski area would be
So
another large
did you,
one.
when breaking this down, look at, revenue and margin per district?
No.
Okay, so that wasn't actually considered in this.
Well, and, so I think in some ways, it was a long time ago. We had a committee. We met up in Walden. We met down here. Talked it round and round. We looked at a lot of different things. I think that our members, as Ty mentioned, have a very strong franchise and the ability to have one member, one vote, and challenge what the board decides as a safety valve to whatever bad decisions we make. And that gives them the legal, as a board, it can put us in a little bit of a tight spot if people get really riled up and they care about this and they want to see the districts changed. But on the other hand, I think it gives us a lot of protection that we can't, don't sue us, make the change. There's equality of representation. There's one member, one vote.
But it's not a franchise of equal strength.
Their ability to challenge our policies is equal strength.
That's what you want to ride on?
The representation on this board is not equality of representation. It is to the practical extent, I think. That's what this board decided in the past, is when you take into historical, let me just read it. What the board landed on last time was that establishing equality of representation by directors of members to the extent practical, given the historic development of the cooperative, the natural and geographic conditions, the existing residential, commercial, and industrial development, and the potential changes in growing of population and development in the succeeding 10-year period.
Yeah, so, that's an interesting point, because I think in this cooperative, we sometimes, every cooperative has its own origin story and its own mythology. And we talk about, even on our website, how North Park had a co-op, and then they, got some financing from the Rural Utilities Service, and they merged with the utility that was serving others. So I, did a little investigation of the Historical Society and read that really nice history that Rob maintains of our co-op too. And it's interesting. So it actually turns out that prior to the 1930s, so we're talking like 1920s here, Kremling, Hideaway Park, the predecessor to Winter Park, Fraser, Hot Sulphur, Tabernash, all had their own public utilities, their little municipal utilities. And then they kind of combined, and there was a Citizens Light and Power that served Hot Sulphur, Granby, Tabernash, Partial, and Grand Lake. There was also the Mountain Utility Company. And so what happened in the late 40s and early 50s was this merger, right? Where these utilities decided that they could get together and serve citizens for a lower cost, if we all got together and established a mutual cooperative. And there were some holdouts. There's even in this history some talk about, I think it was Kremling, that, the municipality didn't want to give up its public power district. But Mountain Parks Electric essentially took it to the voters and said, we could actually lower your costs. And then the voters said, okay, we're going to get rid of our own utility. So now we're in this position, right, where we're citing this historical development. But it seems to me we're not taking that full history into account. The fact that some of these towns had their own utilities, the fact that under Colorado law, some of these towns could have their own utility again, and perhaps do it for a lower cost of power than what we're able to provide. And so why aren't we trying as a board to make sure that you really are the provider of choice? We already take, a lot of those meters. Every member represents usually a meter or more. And they're all paying the same amount to be connected to our service, in part because that helps us provide power to these rural areas. And yet we're telling these people in the more concentrated areas that they only get one director per 3,000, whereas the rural areas, that we're helping to support get one.
I think we're arguing about the approach, which is the last one, which was to do nothing. As we talked about approaches. So before we get into the do nothing and argue over that, I guess I would like to hear from directors how they feel about the various approaches that we, go ahead, Craig.
Well, one approach was, I think I made a note, read my own writing, voting service area wide. versus voting by district, whether that would be for a district position or for an at-large position. My view on that is I would be against that. I very much enjoy that districts vote by districts. And so if I'm for that, then that automatically makes me against an at-large
Okay.
position. And I think I'm an unaffiliated voter, but we've seen in past elections countywide that whoever joins a certain party wins. And it doesn't matter what the qualifications of the other candidate are, they can't win because just we're, skewed.
Right.
No geographic entity is perfectly 50-50 politically. But I think that would be a vote no for me
Okay.
to have a voting
At large.
service-wide
Okay.
or
So-
at large.
Justin, how do you feel about voting at large? So you'd have a district nomination.
A little bit. I could go either way, but I look at the cost also of mailing out and
And
17,000 ballots every time and counting all those. That seems, and frankly, I feel like I think geographically, I like the representation geographically too.
okay.
By district.
Yeah.
What?
How do you feel about the one approach to deal with equality of representation, which would be nominating by district, but having the vote be at large by the membership?
I have the same sentiments as my neighbor here does, because the members in my district would have no idea who a director from Fraser was, and to have a comprehensive vote or an intelligent vote, it wouldn't work. They would either just not vote or something else. I don't know. But to Kristen's point here, if we're want to move towards population, we might as well have all the directors come from Fraser, Winter Park, and Granby. And that wouldn't be very good for mountain parks, in my mind. I like the diversity and I don't think that any directors here are trying to corner the market or control the board vote. I think we're all do our fiduciary duty and do the best for Mountain Park. So in my mind, I think it's a non-issue, but I wouldn't be in favor of that. And one other thing is that my question to Ty about the seasonal thing, do you know how many of your members are eligible?
No, how many are yours too? Yeah.
Eligible to be a director?
Yeah, there's over 700,
700.
and you have about 400 in your district.
So 700 out of the 3,000 are all that are eligible to vote, are eligible to be a director, but all the membership can vote.
People who have the local address. Now, some people are locals, but they may not have updated their address in the Mountain Parks paperwork. That's entirely possible too, especially after the pandemic. But, suffice to say, a lot of people like to say that because someone is not a primary resident, that they're a second-class member. And we treat them like second-class members. We don't give them an equal opportunity to have a say on the board. But as board members, we are supposed to take into account their concerns and treat them fairly. Independent of what Ty might said, Colorado statutes do say that cooperatives are not supposed to discriminate, and that's usually interpreted as regards to rates. But if you read the statute closely, it says as to rates or any other matter. So if we're discriminating, I don't even want to get into a conversation where I'm arguing with you over whose district has more permanent residents, because in my mind, They're all our members and we need to treat them equally.
Well, I think we do. I don't want to get into a debate either, but if you look at the membership that is eligible to be a director, then they're pretty much even or more even than they are now, and we are discriminating against them. I mean, that's just flat out because they can't be a director.
Jump in here.
I'd be happy to go into executive session if you'd like to.
Yeah, I think when we use the word discriminate, we're not using it in the legal term, well, maybe Kristen is, but you may not be. There is a difference. But whether it's, I don't believe it's out and out discrimination from a legal perspective.
Even when it comes to eligibility, we still have a substantial unequalness in terms of who is eligible from each particular district to vote, if you look at the census data.
Not to vote.
To run for the board.
To run for the board.
We don't have that data, do we?
We don't.
Okay,
Here.
so I'm not even going to ask Jeff about voting at large.
I think, yeah.
I think we beat that up. I'm not sure. I think that, Kristen, are you more in favor of voting at large or with changing boundaries? Or
Well, I think voting at large certainly addresses some of these conflicting hats that we have to wear. I mean, our bylaws literally say that we are elected by the members of a district to represent that district. And yet when we talk about fiduciary duty, we talk about how we have to represent all of the members. And that does set up a fundamental conflict because our bylaws that, in our bylaws, we commit to our members that they get to elect a representative to the board for their district. So if I'm not on the board, but if I'm a member of Fraser, that's my only really recourse to try and alter, the dynamics of my cooperative is to elect someone who's going to represent me. But if they then get into the boardroom and they try and represent me, but then they get scared by the attorney presentation and saying, okay, well, I don't actually represent them, then that actually sets up like a really challenging moral conundrum. And if everyone in the cooperative elected the directors, well, then that would, make that alignment a lot more common sense. You represent everyone has a vote. Yes, you come from a particular district to assure geographic diversity, but you don't wind up having this conflict where, our bylaws say one thing, but then our attorney's saying another.
I would.
So I'd like to jump in there. I want to clarify what Bryson said and what my position is on that. You do democratically represent your district. Your fiduciary duty is to the entire co-op. I don't believe that is a conflict. I believe they're two different things. What your fiduciary duty is and who you're elected by are two different things. And I do not believe that is conflict.
Appreciate the clarification. So we do represent our members, but we do have a fiduciary duty too. And from a fiduciary standpoint, I think this is important because we do
real quick, your fiduciary duty is to the co-op.
To the co-op.
Not to the members.
Yes, understood. So I represent the members of District 1.
Duty too, so I just wanted to clarify that statement.
The fiduciary duty is to the co-op, which is constituted of the members.
No, it's owned by the members. The co-op is a separate legal entity.
There we go, which is owned by the members.
Yep.
Thank you, Levi.
Yep.
All right. So from a fiduciary duty to the co-op perspective, I believe that having greater equality in our districts, if we're going to remain within districts, would be beneficial to the cooperative because it reduces any possibility of a legal challenge to whether or not we're operating democratically, which could result in us losing our tax exempt status. And as a director, I feel like keeping our tax exempt status, especially with some of the new tax credits that are refundable for tax exempt co-ops are coming up, is incredibly important. So, from my perspective, I look at that. And then I look at the possibility for unrest in districts that feel like our cooperative is not moving fast enough towards renewable energy, or that it's, if we're going to raise rates or move to formula rates potentially in the future, you could see a scenario where some of these same entities that have been approaching co-ops approach towns and say, hey, back in the day, you were convinced to join this co-op because it's, more economically advantageous to you. Maybe you should form a muni and it would be more economically advantageous to you. If we maintain the status quo, I feel like that puts us at a greater risk that those arguments hold greater weight.
I think I will speak a little bit to the muni side of things and the unrest. I think if this board really listens to our membership and we listen to each other and we make the arguments about why a course of action is rational for this co-op, we will reduce the chance of unrest. I think right now there are people who want to move faster on renewables, see more urgency, and there are people who think it's the worst idea in the world. And I don't know where the vote comes out on that. But in my perspective, we have to listen to each other, and ultimately it comes down to our reliability, our ability to control prices, and in my mind, our ability to source responsible power. And I think we're damn close right now. I mean, we're working on all of those things for the membership. And right now, as far as I know, we haven't had towns coming in saying, we're going to jump unless you do X, Y, and Z. Yeah, we don't have the programs that Excel has that's like for the Marshall Fire folks who are getting a $40,000 rebate to build a super efficient house, because our membership isn't willing to, or so far as a bunch of directors, we have not asked our membership to have an add-on to our rates. Is that somewhere where those towns would want us to go? I don't know. Could we get in a pickle doing that? Yes. But I think if we listen to each other and really try to understand what our members want.
Don't we now?
If we continue, Carl. So
Well, why
if we
wouldn't we
continue, that's
Why
what
wouldn't
yeah.
we?
Oh, I agree with you. I just think I think we can tinker with some boundaries, but I think we're in a good spot right now.
I have to agree, and I think we're trying to make an issue out of an issue that's not there, but that's my opinion.
All right, people of District 1.
Go ahead, Craig.
Just a little background. In my 40-year member with MPE, I was a second homeowner. Nina and I were second homeowners for 32 years and full-time residents for 8 years. So I can speak honestly that I treat any member 100% the same, because I've kind of been there, whether it's with the comp center or with the town or with the county. I know both sides with the vast majority as a second home. So I treat every member exactly the same. And I would think that all of our directors do the same. It is the agricultural economy, the tourist economy, the second homeowner economy. It's all very important to our service area. So that's kind of just a little of my background.
Well, and I have to agree with you. I think we all treat them the same. I mean, there's certain co-ops that charge seasonal members a greater service fee than the residential members. But we haven't embarked on that kind of path at all. And I think we, at least in my mind, I do, or try to. I listen to everyone. If there's a complaint, then we listen.
Exactly.
That doesn't mean necessarily that we agree with what they're complaining about all the time. We do listen. I think we do as a board, so.
And this doesn't help with the numbers discussion.
Right.
It just, we're just throwing our 2 cents in as the second homeowner. A member is a member, counts just as much.
It can argue. But if we're getting down to the nitty gritty of who is eligible for a director position, then it makes a difference.
Right, and I think that's a second issue, but that's not what the special meeting was called for. But we can, certainly if people want to bring that up, we can address it.
Do we think that's an issue as a board, or?
I've got to say, it's always given me heartburn that you treat members differently. But certainly other co-ops do it, but for me, it's like, how can you say anyway.
The US
I think the practical.
government does that. You can't be a senator in different states.
You actually can, and there's someone running for Senate that doesn't live in that state right now.
Really?
Yeah.
Well, leaving aside our wonderful world of politics, we'll just stay in the co-op thing. I just, for me, if you're a member, you're a member. But that's my hang up. I certainly understand sort of what that could look like 20 years from now, but maybe it would be good for the co-op. I don't know. But, I'm one.
I think, I don't know if it was Jeff hit on it earlier, that last time board members were added, it's kind of needs to be an odd number.
Right. That's why we increased it.
Yeah, so if we're at 7, one option would be to go to 9. And I guess that would be a big effort to do that, just logistically. But what would staff think of having a larger board to manage? Is it a difficulty at your end, Mark, to have, there's a sweet spot on board size, just from a management perspective?
I have been worked with and been a part of boards that were 5. It's almost always an odd number because it prevents it from being something that you end up with a tie. 5 to 17. 17 is really difficult.
Not 44.
42.
42 or 44 is even worse.
It's even, and there's a lot of them.
I think that realistically, to be able to, for the board to function well, this is just my personal opinion, that 9 really is the max that you should have. I think that there are some Colorado co-ops that are like us with 7. There are some with 9, and there are, I think, at least a couple that have more than that. And I think once you get above 9, it becomes more difficult to manage. There are times where I was on a board that had 17, and getting a quorum was very difficult because, and at the time I worked for the city, and our board meetings were on Tuesday, and I had to be at the assembly meeting on Tuesday. And so I would get through the consent agenda and make sure there was nothing, and I would race over to the board meeting so that they could actually conduct business because I was the person that made the quorum. So I think that quorum becomes more difficult as you get further along. Just from I don't know that staff manages the board, to be honest. But it becomes more work associated with it.
Just in terms of communication.
Yes.
That was my intent, just administration management.
Yeah. And that is a consideration. But like I said, I would say that for an organization this size and with the number of members, I would say that 7 probably works. There's 5, 6 co-ops in Alaska, and the largest one has 90,000 members, and they have a 5-member board. The smallest has, I think, 6,000 or 7,000 members, and they have a 7-member board. So I think that, it depends on, the co-op and the geographical area. The one that has 90,000 members in Alaska has a service territory that is 300 miles long, and at its widest part is 100 miles wide. The one that has somewhere between 25 and 30,000 members is 100 miles long and 100 miles wide. It's kind of like a plus because the membership follows the road system. And they have a 7-member board.
So as we think about numbers, perhaps expanding the board, are we thinking about 2 new districts or 2 directors at large, if you were to go that way? Or
No change.
or no change?
I don't think no change in short order is really an option, given that we have thousands of new units being put in throughout our service territory, which could take this issue and exacerbate it even further.
You have to figure out a compromise between member, 1-to-1 versus the geographic
Right.
diversity
Right.
question.
So Kristen, I have a question for you. Does it have to be 1-to-1 for you?
What?
So that every district is within 0.25% size of every other district for it to be equality of representation? I mean, how close do they
I
need?
mean, I know you're never going to get it exactly precise. It does make sense to take into account other factors. But it seems to me, in talking with some other co-op directors, most co-ops get it pretty close,
What's
No.
pretty close?
within 1 or 2% per district. I've not encountered yet another co-op where if you add up the number of directors, that you could have a minority of members represented by a majority of the board seats. And it seems like to me that's a bare minimum threshold, is that no way you add it up should you be able to come to that result.
Okay, so
Unless you
that's
take
sort
into
of-
account the things we're talking about,
And that our expert also.
demographics.
I was
My
asking my opinion.
Yeah, no, I was trying to figure out where we might find a sweet spot if there's a sweet spot to be found between the group.
On your question on at-large versus, if the board expands director seats in the future, I don't have strong feelings either way. I think that at-large voting has perhaps some advantages that people are not considering, such as the fact that if you change the election cycle, you can send one ballot, they could vote in districts at once, so it would not extend the costs. And it might even be easier to administer. I know, from a personal perspective, that would be, it would change the way that people run for the board. People may not be investing in 20,000 mailers, maybe doing more signs or online advertising, but I don't think that that's a reason to not consider change.
Can I ask you a question for clarification purposes? You said if it was voting at large, that it wouldn't necessarily increase the cost. But if you had the same terms for members or directors and you spread them over the 3 years, you might vote for more directors in that time, but it would increase the cost because currently with.
If you change the timing of when you sent out ballots, I agree.
Yeah, because currently SBS, it's about $18,000 if we run 1 or 2 directors, because the last 2 years we've had two that I don't like the word, but disputed election, contested elections, where there's more than one. So even if we send out those ballots to just the members within that district, it's about $18,000 and typically somewhere in the neighborhood of 23 to 2,500 ballots. So if we were voting at large and we had to send them out to all 17,000 members, it would increase that cost by 5 times. And so it would be $90,000. Even if you had 9 directors, so let's just say that for each, that you had 2 in each of the years, well, and then in another year. So if you had one contested election, it would be $90,000 a year. So over the 4 years, it's $360,000.
I think that's a worst case scenario, and you might be not considering the fact that we recently modified our ballots to allow electronic voting. So if we want, we could explore that. That could, if we get it streamlined, reduce costs. In addition, there is the potential to realign when voting happens. If we elect all the districts at the same time, obviously this becomes a one-time mailer every several years or whatnot.
Okay, so you were, if I understand what you're saying, you were suggesting that if there are 4-year terms, that you vote on all, however many there are, 5, 7, 9, all in the same year.
If the members wanted it, you could do it that way.
That might be a problem for, well, I mean, I don't know, maybe. But right now, the way we have it, there's some carryover of board members.
Yeah, I think
it provides some consistency of direction to.
Or I'd hate to have.
It would be uncontested, in which case they would get their seat.
But it would be hard for the organization if, I mean, we're in the middle of our negotiation with the power contract and all of a sudden everyone's gone. Mark could then dictate how he felt the whole board should operate, basically by how he approached the whole new board, right?
Well, I think it could create some.
Depending on who was on the board.
If you see what I mean, like,
yeah,
you don't have to, I mean, we're not there to say, well, this is actually how the board originally thought of this, and however you present it to the new board.
A question for Levi. If a co-op has electronic voting, because I'm a member of 2 that do, are they still required to send out paper ballots to all members?
I'm just deciding whether to. I think I should probably answer that in executive session.
Okay.
Yeah.
Okay. Is there, I think we heard from, other than Kristen, I think that board is sort of at the idea that voting at large, whether for at-large candidates or voting at large for candidates who are nominated by their district, is not something y'all want to pursue, other than perhaps Kristen. What about, as Cray suggested, considering adding 2 districts versus doing nothing? Or I would even throw out considering districts, adding 2 districts, but thinking about it 2 or 3 years in the future.
I just want to clarify that adding 2 districts was not really a suggestion.
Okay, it was just throwing it out.
It was more of a discussion,
approach.
Especially at the administrative
level
arm of things, the difficulty staff might have. So I threw that out, not that there was a desire. It was just a little bit of discussion.
Approach. We're supposed to be going down these approaches is what
And adding about 400 meters a year, is that 400 members per year? That without the fire involved, that's kind of the path that we've been on the last 4 or 5 years.
It's 4 or about 400 meters. And what we have seen is when we add meters, we don't necessarily add members.
Yeah.
Because if a developer like Grand Park, and they're building a bunch of homes, they will apply for service, and all of those meters will be in the name of Grand Park until they sell them. And so typically the 400 meters equates to somewhere close to that in the number of additional members, but not always, because there are people that own multiple properties.
So where are you seeing that development happening? Like I was recently reading in the paper of a new 3,000 unit development that would be in District 2. There's a pretty sizable development, Rome, that's going in that affects District 1 as well. Granby obviously has a lot of development. Is there a lot of new members coming in up in Jackson County in District 4? Like where are you seeing the growth patterns happening?
Well, you mentioned Rome. They have plans to do quite a few, but they also had indicated that they would be within a short period of time, and they have slowed down their development. There are developments that are happening in this area in Granby. So I guess technically that is what, District 6?
Or 7.
6 and 7.
6 and 7. The Sun Properties and they've been putting up stuff pretty quickly. The town of Granby, the town of Fraser are putting in additional housing capacity. The Winter Park Resort sent out that information. They are looking at somewhere in the neighborhood of 400 units, 2 buildings for employee housing. And to Liz's question earlier, who is that meter in the name of? And so do you have 400 members that are there for a period of time and they keep rolling over, or are those meters in the name of the resort? And so it really still stays within the resort.
It is that meter actually, I know that the ski area, from what I understand, at least on the hill, has basically their own system. They have a huge service, and then they take care of everything behind that service. Whereas, and so conceivably some of that stuff is on that service. It doesn't even grow the number of meters per se or members per se. It just grows their load. I don't know how they're doing it. I know a lot of their other buildings like CMO or, Founder's Point, they're all metered separately. But
I think it's somewhat like the
Granby Ranch YMCA.
yeah, the YMCA.
Right.
That we provide the power to a point, and then whatever they are building behind that, they own that system. And so it doesn't necessarily increase the number of members because they are one member and we provide the power to them and what they do behind
So they're
there.
going to be master metered?
It's not mass meter. We provide it to the resort, YMCA, and then they own the electrical system, the secondary system behind.
Oh, you're talking about YMCA.
Yeah.
I thought you were talking about
Is
the new
some-
development.
I'm sorry.
I have to be.
Is Sun Communities all individual meters for the most part?
For the most part.
The little
Because-
houses and
Crossing, for sure.
modular.
Yeah, the way that it ends up working is, they have Sun Properties is River Run, and it is also Smith Creek Crossing.
Right.
And the Smith Creek Crossing they're building, but those are individually owned. Most of the stuff within River Run is not individually owned. It's owned by the resort.
Yes.
You
The
can,
campground.
yeah, you can, I believe, buy what they refer to as a cabin within the area, and then it would be a meter for you. But
Some of those cabins, you buy the cabin, but you pay a monthly rent.
yes,
On the.
and that's what River Run is.
Meters.
Yeah, River Run, Smith Creek Crossing is you own the structure.
Yes.
You don't own the land that it sits on, but all of those are individually metered.
Thank you.
So, do we have any other thoughts on adding a district approach?
Well, just to clarify, Kristen asked the question, where is the development? I think the development is probably the majority of it is from hot sulfur this direction. There is some in Grand Lake. There is some actually that Craig is involved with in building houses in hot sulfur, but they have challenges within that area. Kremling,
I think Kremling.
Blue River, they have,
Okay.
we're getting, I would think, single-family home pressure coming up 9. I would guess there's not any, from what I understand, there's no water and sewer
yeah.
in the
And
Grand
that's the
County
challenge
side
for
of
hot
that.
sulfur is the water and sewer capacity.
But we're going to see a lot of new single-family homes, I think, in the Summit County area.
Does the District 4, that kind of cut off at Highway 9, how close to Silverthorne is that? Is that like where that shopping center is, or is that still something?
No,
else?
it's
Do you know where the guy with, he has a windmill and solar house?
The Red Ranch?
No, he's on the left side of the road there, and he has a wind turbine and a solar farm.
I'll look for it next time.
So that's like
From
right at the
Silver-
line, right, Joe?
Sierra Bosch is the furthest we go south.
Yeah.
Yes, that's basically the last time.
Yeah, from actual Silverthorne, I think it's like 8-10 miles.
So it's kind of past the canyoning part and then kind of
Yes,
flattens out.
kind of.
So it's not where they're
Gravel pit
developing those new condos.
It's before the gravel pit,
Before the gravel pit.
before Everest.
That's several miles before the
Before
gravel.
Everest.
Yeah.
Yeah, there's no new condos because of the water and sewer, I think.
The Jackson County District has been affected by Malone and some of our larger landowners buying lots of ranches and becoming one member too, whereas those used to be all individually owned properties. So if you own 10,000 acres and used to be lots
Would
of
we
members.
have, well, it might help your question, but out of 2024 customers in 4, how many are Summit County? I don't know if that's an easy question.
Might be a question for Mark.
Probably not that many.
Few hundred?
300?
It's less than probably 500-700, I would think. I mean, and probably below 5.
Okay.
Because if you drive along Highway 9 in that area, there are not a whole lot of houses alongside the road. And basically, we serve kind of along the road.
Yeah.
What it would happen if you put all of the non-grand counties together into one district? It wouldn't be contiguous, but it would be an interesting question.
We wouldn't have nearly enough. Or I think it'd be smaller.
Well, if you
District
said
menu.
700, if you added 3 plus the 5 to 700 in Summit, that starts to approximate equal.
We would do that because what would be the benefit?
Well, then if you moved 4 over a little past hot sulfur and rejigger those other boundaries slightly, then you get districts that are closer to that 2,500 per district, which would be equal districts.
Are you saying put Jackson with Summit?
Well, I think what, and correct me if I'm wrong, she is suggesting putting Larimer, Jackson, Routt, and Summit counties all in one district.
Just asking what would that look like in terms of numbers?
And I don't know. I mean, we could,
It would mean whoever represents it would have to get a new vehicle.
Because in the event that you had to go from Larimer
Let's not
County.
pretend there's not phones, like.
I know, but how would Winter Park feel like if they were, a corner of Winter Park was mixed with Calgary? We just decided to put the two of those together.
Well, given the lack of transparency over our voting maps, I'm not sure they would ever know. But,
Well,
you know, how would the people of Jackson feel if we gave, Winter Park with its 1,000 permanent members, one board seat, while, all the thousands of people in 3 and 4 plus some more only got one vote?
I don't know. I think that.
The members in Jackson County wouldn't be very happy with that because the directorship would come from 1,000 members. Same with combining it with Grand Lake or whatever. I mean, you're essentially eliminating their voice in the co-op. Because of numbers.
I think that there's a distinction to be made between voice and power or voting. I mean, I think that Kristen is equating voice with representation. I would say voice is the ability for a director to come to this board and express their feelings about whatever the co-op business is and how it may or may not resonate with the members or the communities that they're
Within
from.
their district.
Yeah. And so I think that there is some, again, going back to what I said before, I think there's some distinction between, an approach that tries to hear the voices and an approach that tries to equalize, make sure that everything is actually really proportional. And I think that's the hard place that we're in right now. I've got to say, I just don't think that having one director who's supposed to give voice to people who live on the Blue River and work in Summit County, to expect that director to understand what's going on up in Cowdrey or Laramie River is going to be really difficult.
Or Winter Park.
Or Winter Park.
And
I
think you have to be careful because, it's not even necessarily the case that someone that lives in unincorporated Fraser knows what's happening within the city boundaries, or someone in Winter Park knows what's happening in Fraser. Yes, there is closer physical proximity, but when it comes to voting power on this board, the fact remains that we have 3,000 plus members in certain districts and fewer than 2 or fewer than 1 in other districts that get the same voting power. And that does set up a difference. So my question to you all is, I see what direction you're going, but how different do the districts have to get in terms of disequal numbers, uneven numbers of members before you will redistrict or add seats? Like, do you think it's fine to have 906,000 in one district? Clearly that was too much. So you went through a process of redistricting, but like how unequal is acceptable?
Like, that's a good question. And I think it's something that the bylaws ask the board to review. I mean, we have that at the maximum, or to look at this every 10 years, we can look at it more frequently. Right.
This doesn't solve anything, but just food for thought is we've seen Fraser and Winter Park do written studies on consolidating. And they did take the first step years ago with the Fraser Winter Park Police Department.
Right.
There has been continued talks. Whether they're going anywhere, I'm not privy to any of it, but there is talks down the road at Fraser Winter Park merging. And that would be another little conundrum on the districting, I think. But I have no idea if that's 1 year or 20 years away. But they did do it with the police department, and it's been successful.
In the chamber and a few others.
That's right, in the chamber, yeah.
What if you merged those districts and just, like, if you merge 1 and 2, but they get 3 board seats if there is growth? That's kind of a hybrid if you're by district and then by at large.
To look at it the other way, I remember when they redistrict our state senate, and I think it was Winter Park and Fraser that wrote all those. I mean, they did a whole study and wrote letters because they got put in a folder. It was unacceptable to be represented by this huge mass down in Denver at the state capitol. And I don't know where that currently sits, but I remember that being the hot seat in the paper for months. And because Winter Park and Fraser did not want to be represented by the Boulder community. So it's sort of the same, I mean, it's just Carl's community's the opposite scenario here.
It's the Front Range runs the state.
Yeah, and it was, they went round and round, and I remember the same thing. They were not happy about being involved in that group there.
Kristen, to your point on having a district with more than one director, I think that would be, personally, I think that would be difficult because it's like, well, you have more than one director. Who gets the vote? Yeah.
It also
I'm not
helps you
saying the
remember
right
that
words, but
we're a co-op.
who's representing who
Yeah.
within that district?
Well, you'd be representing the district and your
But
fiduciary.
somebody else
duty
also
be to
would
the
be
co-op.
too, and I see that. Maybe I'd almost rather have more districts.
Like how the towns vote. You have town council members.
Yeah, they all represented.
Yeah. I mean, it's just one more solution without having to go back and get the GIS map out again, is consolidating some districts and having 4 reps for 3 of those areas or 3 for 2, depending on how the growth goes. But this growth is happening, and I haven't heard anyone articulate a coherent philosophy of what measures have to be met before we add a district or before we do something. Like our bylaws outline the time requirements, but there doesn't seem to be any consensus here about what constitutes the heart of meeting those requirements, which is how are we assuring that we're establishing equality of representation by directors of members to the extent practical. Like what criteria are we using to determine whether we meet that bar in our bylaws of have we established equality of representation by directors of members to the extent practical? And then there's all the qualifying things that allow us to mitigate and, modulate that, including geography. But like, that's what it says. And I'd just like someone to articulate for me how you think we can do that.
I think the guidance we got from Ty this morning is that there's great latitude, and makes it more difficult.
But
So
even
the
if there's
guidance
great
is-
latitude,
yeah.
we need some coherent philosophy about, okay, how do we decide as a board, as a cooperative, that we have established equality of representation by directors of members to the extent practical? Is it when, a certain number is exceeded? Is it when one person raises a stink? Or
I think, I think Ty spoke to that a little bit about how subjective things are. And so I think you're asking for a philosophy or something that would put a number to that.
I'm asking, does this board have criteria by which we determine that we have established equality of representation by directors of members to the extent practical? And from the silence, I'm gathering the answer to that is no.
Because it's a subjective question.
Yeah. Haven't we been talking about that? Like, I think we've all voiced our opinion on that matter. It's not just about numbers. It's just not. It's about this whole map and everybody in it, not just 1 and 2.
Okay, but like, how are you considering those other factors then? Because like,
There's a geographic, there's
okay.
different demographics.
So how are you incorporating those in your decision? Like,
I think that Ty.
just like Jackson will always have its own director just by virtue of the fact that that's where the border is?
I mean, I look at it, I feel like I'm reasonable, and I wouldn't, unless in all of those grew twice over, then maybe we need to look. But if each one had 4,000, I still feel like it's like this separate area that needs representation, in my opinion. And I feel like we work well as a board. And who knows if Carl doesn't run again, if the next person won't work well as a board and they have that vote. But when we come out of all our board meetings, I feel like we're united, and I don't know.
I think the difficulty is that Ty has given us great latitude. And, from other co-ops. And so it's difficult to quantify or qualify an exact rules or philosophy.
Prize
Exactly
interpretation here.
where we need to go. We do have this latitude, but I think you just hit on it. Do we function? Yes. Do we get things done in a polite way? Yes. Again, my first comment a long time ago was the geographic diversity. And I think that gives us a lot of latitude. If we always have it perfectly member by member by member by member divided by 7, it's always a moving target. Could we do better? Maybe that's why we're here. I don't have any perfect answer.
You could almost combine 3 and 4 all together. But again, that's pretty big.
You're going to lose some benefit. Yeah, I mean, that certainly was talked about in the last time.
Yeah, I remember.
The last time we did this, and ultimately the decision was no, combining 3 and 4 is not a good idea.
It was like 3, 4, and hot sulfur, if I remember right. We were all in there, and then we were chopping up Winter Park before.
Right.
And then it was.
Have you considered that we may be in a situation where we have allocated less voting power to people who are bearing more of the burden of the costs of the cooperative?
I think
Yes, that's the cooperative principle, though.
Is cross subsidization? No, it's not.
We
well,
all know that it costs more to serve somebody in Cowdrey than it does in downtown.
At least
so
give
I
them
would
quality.
argue in some places where we have to bore and underground and work around a lot of utilities that actually might be fairly expensive to serve in some of the really dense, complicated urban stuff. But that being said, this is going down the path of the of the rate design committee at Tri-State over subsidization. And I think that, again, if we listen to each other's voices, which I think we do, and we take into account the various points of view of our members, that as a board, we can function and we can keep our members pleased with what Mountain Parks is, the direction we're going in, and how we function. And what I'm hearing right now is, other than Kristen, nobody feels like there needs to be a change to the districting at this time. Now, I would say that that doesn't mean that in a year or two, we shouldn't go back and consider if those areas have grown a ton to adding additional districts or something. But we need to be strategic about.
What is a ton?
Exactly.
What's a ton?
It's in my gut is what a ton is. It's thinking about whether I can sleep with what we've done, whether it's morally right. And right now, for me, we've got a lot of stuff going on, and this doesn't rise to that. It doesn't wake me up at night. Go ahead, Craig.
I agree with you completely. I think we should move forward because we know things are changing. We know that our responsibility is not to our district, it's to the entire service area. That's our responsibility as a director. And we've been told that today, we've been told that in the past. But I would like to move forward with just investigating, because the GIS world is changing every day, that we see what it would take to develop a tool to massage things and quickly look at, because we do know that our numbers are skewed.
Yep.
But I work for the entire service area, not for District 2. That's my responsibility. But if we could have a tool to look at what ifs, I think that would go a long way towards the discussion, because there's no way we can define, unless it's member to member and everything's equal. There's no other real definition. There's no definition of geographic diversity that we can adhere to.
Yeah, I think developing that ability to do that over the next couple of years would serve the co-op well for the next 100 years. If we didn't have to go out and hire someone to do it. And that we could perhaps tweak things in a more, if they got tweaked every 2 years, maybe we wouldn't end up with big inequities. But, there's no guarantee of that, but it would allow us to play with it and see it.
And that you could play with moving boundaries.
Yeah.
You could play with adding districts.
Right.
And using
You could-
roads as I like that idea too, using Highway 40 as the dividing point opposed to this.
Certainly
Yeah.
makes it easier.
And sort of county road, we're going to use county road 60 or 8
Yeah.
or whatever. And that would be less likely to get a line right through somebody's meter, which I think when you do the straight lines like this, there are people who live pretty much on some of those.
Because I'm certainly sympathetic to Kristen's concerns, but then it's just a, southeast service area maneuver for the future.
Right. Well, I think we need to be, as a board, cognizant of the fact that there are a lot of meters and a lot of members in that area, and we should listen to them. Anything else?
How do you decide where a member resides in their district, or how do you decide when somebody has meters in multiple?
They get to
They-
decide.
It is,
They have to specify where they vote.
is decided, they get to decide.
They let the co-op know. And I don't know how you track that.
So it's not where your tax return is filed or where you're registered voter.
I think that would be if you wanted to be on the board.
Yeah.
As opposed to.
Just vote in the election.
But the voting is decided by the member if they have multiple meters. Oh,
Anything else? Thoughts?
Good luck in your election, District 1 next year. Sorry.
I can, if the board would like, see what it would cost to have a contractor develop the model, which we had talked about before, has been mentioned today. And then with that model, you would have the ability to move district lines, and it would then tell you how that changes the membership within each district.
Because I thought you had said that before, Mark, that's not something we can do in-house, is it?
No, it's not something we can do in-house. We don't have the expertise. As mentioned, we moved from ATS to NISC. They like letters and not having to say the whole name. And when we did that, we moved from a software that was Futura to MapWise. And we have expertise in Futura. We don't have expertise in MapWise. And MapWise and GIS have to work together in order to create that model. There are individuals that have that expertise. We don't currently in-house.
So the metering that's remote now, does it have a geographic location?
Yes.
So we're partway there.
No, but we have always been that way. So what you could do is you could take the metering data that you have, so the location of the meters, and you can overlay it. I mean, that's basically how we come up with this data, because it's based on the address of the meter.
Yeah.
Or address of the member. And then if you create a model that has that and it merges the two things, so it merges MapWise into GIS, and then you can basically move lines on it. So if there was a line that in the Fraser area was Highway 8 and you wanted to move it up to where it was Highway 5,
Right.
then you could do that. And how much does that change the number of meters within the discrete area that you have changed?
Could we decide today as a board to
Pursue
ask
that?
staff to get a proposed cost proposal?
Yeah.
do,
Absolutely.
to do that, not to go out and buy it, but just see.
Well, and we,
Mark already volunteered to do that.
Okay.
yeah, I don't believe we need to buy anything. What we need to do is pay somebody
Yes.
to take what we have and give us a tool that will allow us to do it.
Yeah.
That'd be great. That'd be good. Okay, any other old business or new business? I think that was on the agenda.
Do we need the executive session? Levi had it.
Oh, Levi, do you, yeah, would you like to,
Oh, the vote.
You'd like me to address Mark's question? I'm happy to do that.
Are we in a second?
would you, yeah, would the board like to hear Levi's answer to that question?
Please restate the question.
The question was whether or not,
The need to mail ballots if we offer electronic voting. And there was another question, which was one of the board members' questions that Levi also suggested that would be something for executive session.
would you like to hear the answers to those?
Yeah,
Okay.
if you're looking at going that
Yeah,
route,
then let's have somebody have a motion to.
I'd make a motion, we have executive session for legal advice on balloting and elections.
Second.
All in favor?
Aye.
Okay, and we cut the feed.